Hello and welcome to this recording about standards and regulations related to security. All right, I'm going to start first by talking about what are the standards and what are regulations. So, standards, generally speaking, are recommendations issued by standards organizations and or some other group of organizations that represent an industry. And there are recommendations in nature, so they are not mandatory, but there are recommendations uh, which, for many reasons, organizations wish to follow. Regulations, on the other hand, are issued by governments and they apply to specific organizations that fall under the jurisdiction of that government. So let's start by talking about security standards first. So these are some of the references, and I'm going to talk about mainly three groups of standards. The first one is the ISO 27000 series, and then SOC, and then the PCI DSS. And for each standard, I'm going to talk about the scope of the standard and which organization it applies to, because not all standards apply to everybody, right? So, as I mentioned, standards are recommendations. They're not mandatory, but there are many good reasons for organizations to follow the standards. One of them is probably because the jurisdiction or the governments forces them to follow a certain standard. So that's one reason, and in this case, the reason would be just compliance with the regulation. Sometimes the organizations wants to follow the standard to show the customers that they are following specific rules for security, so this customer should trust them because they follow these rules, right? Sometimes if you are a customer and you see two organizations, one follows certain security standards and publish or talk about it, the other one doesn't. So you may incline to follow or to do business with the company that follows the security standards. So now there is a competitive advantage for the company to follow certain standards. Sometimes the organization follow these standards as a form of a risk management. So you have security risks, and one of ways to respond to risk is by mitigation, by avoidance, by acceptance, and by transfer. So one way to mitigate the risk is by following security standards. So we're part of risk management strategy. Another reason is just for the sake of improving security. So rather than rely on your IT department to come up with their own security measures, you may want to follow some published standard because it was designed by maybe people who are more expert and they know what they're talking about. So it's easier to follow recommendations came with from people who are experts in the field. Sometimes it's the industry that imposes on itself these standards. If you are a supplier and you are supplying material to other companies, your customers, the other organization that you want to supply material to, material in this case, information databases, cloud services, whatever, right? So they may want you to follow certain standards so they feel comfortable doing business with you. And sometimes following certain standards is better than just stumbling upon different mechanisms and different security measures. You just want to follow specific standards for operational efficiencies, right? So you follow a certain process and you achieve security by following that process. So there are many good reasons for following these security standards. Most security standards comes with certifications. So you want to follow the standard. That by itself is good, but you also want to show off that you are following the standard. So you get a certification. So there are organizations that issue these certifications by looking at your measures that you do in the organization and give you a piece of paper that says, well, this organization, we looked at it and they are following these standards. So we are test to that. So they give you a certification that you use for marketing, used to put it on your website, you include it in the contract for customers. So to show that you are following security standards. So that applies to almost all standards that we're going to talk about. Okay, the first set of standards is issued by two organizations in collaboration. The first one is the International Organization of Standardization. This is the one that issued a lot of standards that we deal with, including the OSI model, and also another organization, the International Electrotechnical Commission, the IEC. Both of them, they came up with a set of standards. There are so many of them. There are only few I included in this slide. So we call them the ISO IEC 27,000 series, and you'll see here 1, 2, 8, 9, 15, 17, and there are numbers in between as well that I ignored here, but there are many of them. We're going to focus on just two. So the first one is the ISO 27001, and as you can see here, it specifies the requirement for implementing, operating, and improving an information security management system, or ISMS. Okay, so what does this standard say, or what does it do? First of all, let's talk about the scope, right? So the scope of the standard applies to everybody. So it applies to any organization. Any organization can follow the standard if it sees that it's useful for them. And the standard, it says, generally speaking, it doesn't tell the organization what to do exactly. So it doesn't tell them, oh, you have to use a firewall, or you have to use an IPS system, or you have to do this or that. Instead, it asks serious questions to the organization. And by answering these questions, the organization is supposed to know what they need to do in terms of security. So, for example, you see that in the second line there, has the organization identified the applicable legal, regulatory, and contractual obligations related to security? So this is a simple, or one of the questions that the standard asks. So it goes to a bank, for example, say, do you know all the legal obligations that you have related to security? So the organization will start by saying, okay, yes, we know, and these are all the laws that apply to us. So they list all the laws in their answer. Now, if the organization doesn't know the answer, this means that they have to go and find out. Maybe they have to hire a consultant, the lawyer, whoever, and to provide them with these answers. So the process itself helps the organization figure out what they need to do in terms of security. So just by answering this question, the organization probably has a better idea of about what they need to do in terms of security. Another thing is, has the organization identified the information and processes that need to be protected? Okay, organizations, small and large, have a lot of information. what are the information that needs to be protected. So by listing them, okay, we need to protect financial information, we need to protect maybe the list of customers, we need to protect our contracts, we need to protect our trademarks, we need to protect our trade secrets. So you, by listing all of this, you know what kind of information you need to protect, because it may be, I mean, when we say information, this is a really big field, and for an organization that is huge, manufacturer, for example, okay, so these may be thousands of documents, thousands of pieces of information that need to be protected. And also for a small organization, it could be significant amount of details as well. So think about what information needs to be protected in a lawyer office, right? Law office. So the lawyers will sit down and say, okay, we need to, this is the information that we have, 1, 2, 3, 4, and all of these needs to be protected, or most of these needs to be protected, while others may be not as important. Also, the processes. Sometimes the process of manufacturing is significant. The process of creating a chemical is significant. So what are the processes that need to be protected here? And also, now we identified this, what are the security measures that we have in place to protect this information? By listing this, by answering this question, the organization will figure out, okay, so this is we have these things that we do to protect this information, while probably in the process of discovery, we discover that some other information are not being protected. And so, does the organization understand its information system? Now, this may be trivial, but if you look at it from the CEO point of view, do you know what the information system that you have? Do you understand what kind of information system you have? Now, the technical people may not be clear on what kind of components they have. They build systems, there are storage here, backup there, servers here, laptops there, remote users moving around. So all of these needs to be understood by the organization. What kind of information system that you're using? If you don't understand it, you probably can't protect it. So by answering these questions, now you are getting closer to understanding the security information or security measures that you need to implement in the organization. So again, I'll repeat that 27,001 does not really tell you to use a firewall or do this or that, do that, but instead it asks you, do you understand what it takes? Do you understand what you have, right? So by answering these questions, you show that you are aware of your system here and what needs to be protected. And by answering this, and to the satisfaction of the auditing or the organization that issues the certificate, you get the certificate that says this organization is following the ISO IEC 27001 standard. All right, so that's the first standard. Now there is the certification process here. The certification process itself says, well, after answering all of these questions, you need to create a project plan, identify who within your organization will oversee the process. There are some numbers and details here that I'm not gonna dig deep into it. So there are about 114 different controls that, if you dig into the certification itself, you will find more details than just obviously just one slide here. Determine exactly what kind of information you need to protect, perform a risk management and gap analysis. So we talked about risk management before. So part of it is to assess the risk in the organization. And when we talk about gap, means that the difference between what we do right now and what we need to do to follow the certification standard, right? So there is always the difference, and we need to fill that gap. We need to fix things that are not complete or fixed. And then design and implement policies and controls. Right. So if you answer the question, oh, here is all of the information and processes that you need to protect, then probably later, okay, what do you need to protect them? So explain, right? What you need to do in order to protect these. So the certification comes after an audit. Organizations, usually the ISO does not do this by itself. It has other organizations that do the auditing. And of course, the ISO is one big organization, but it has a lot of other local auditors that they do this on their behalf. So they look at the documentation, the processes, and they review them, and they see, okay, so you are following the standard, so here you go, we'll give you the certification. And usually this happens continuously. I'll talk about this at the end, but this process usually continues. So you do this every year, every 2 years, whatever the certification process requires. So it's not just one time process, but you do it continuously. The auditor comes and look at your documentation, you look at your controls, what you have, and then they say, okay, you are still in compliance with the standard, and they give you a certification that's good for another year or more. So this is almost general process for everybody, not just for the ISO 27001. Okay, so the 27002 is more detailed. By itself is not, there's no certificate for the 27002. It just fills the gap for a process like this. So as I said, this is a more generic. 27001 is like a big umbrella of a standard, but then you have to follow some of these details. So certain organizations may say, well, we're going to follow the 27008 because it's more relevant to us, or the 2709, or any other details. So they follow the specific standard. So I picked one of them, which is the 27002. And so this by itself doesn't have a certification, but if you follow this, it may help you get the certification of the 27001. This one has more details. It has guidelines for 12 security areas, and you can see here risk assessment is one of the formal methods for identifying and classifying risks. So it tells you what to do in terms of risk assessment. It tells you what to do in terms of asset management, physical and environment security. I'm not going to list all of these, but I'm going to just grab a few. Business continuity management. This is usually the procedures that an organization put in place in case disaster happens, not just security, but any other financial disasters or environmental disasters, whatever, that what the organization can do to recover quickly and continue the business after this disaster. So all of these has the 27002 puts specific details into how to do or how or what to follow in these 12 areas. So it has more details, right? So back to the difference between the two here, 27,001 and 27,002. The 27,001 is a management standards outline how to establish, implement, maintain, and continually improve information security management systems, ISMS. So it is actually the standard by which the organization can be audited and certified. Right? But the 27,001 is more of a code of practice, more details. It tells you exactly how to achieve, or in more detail, how to achieve the security. And it says here there is an appendix A, and there are more details here. It goes into much more detail about each control compared to the 27,001, and the organizations don't get certified. You don't see a certification in 27,001, but you can use it sorry, you cannot use the 27,002 for certification, but you can use it to get the 27,001 certification. So 27,001 focuses on the processes, while the 27,002 focuses on more specific controls. That will dig deeper into the details. I may say, just to clarify it more, the 27,001 is something that maybe the executives of the organization can understand because it's high level, while the 27,002 has details that probably the technical people will understand because it has more detail. So this is probably an analogy that get you to understand the difference between the two. All right, so the ISO made the 27,000 series. Another organization created something called Service Organization Control, which is SOC. So SOC, defined by the American Institute of Certified Public Accountants. All right, so why accountants do certifications related to security? Because actually accountants or this organization in particular have the habit of, or the part of their business is to go and audit or other organizations. Usually they audit them for financial statements, right? So they go and look at their books, accounting books, and then they issue a piece of paper that says, we looked at all their financial records and everything is up and up, right? So as part of their business, they may, because they have this ability, they may go and do something related to security as well. So it has the same kind of feel. They go into an organization and audit their security controls and security measures and processes, and they issue a piece of paper, a report, maybe not a or literally piece of paper, but a report that says, okay, we attest that this organization is following security practices. The report focused on controls grouped into 5 categories called trust service areas, and these control criteria are used by the practitioner examiner, which is the accountant. There are 3 types of reporting: SOC 1, SOC 2, and SOC 3. Each one of them has a slight scope and in terms of organization and also audience. Okay, SOC 1 is targeted more toward organizations that provide financial businesses to other organizations. By the way, the SOC in general, it's targeted toward organizations that provide information services to others, right? So information services does not mean necessarily IT, but if you are doing accounting, if you are an accountant, or a payroll organization that does payroll for others, now you are targeted by this SOC, right? So if there are, for example, if you are a small business, you may not be the one who issues paychecks to your employees. Instead, you are hiring an organization that does paychecks. So the payroll is handled by somebody else. SOC targets that somebody else, right? So you are a doctor's office, you have employees, and you are issuing them paychecks by the end of the month. Usually, the doctor does not do this by themselves. They go and hire a financial institution that does this for them. So that financial institution wants to make sure that they are following the security standards, so they do SOC. They do SOC 1 so that they show to their customers, the doctors, that they are following good security controls and the good security processes, right? So SOC applies to organizations that does financial services to others, payroll, payment, things like that. So SOC 1 assures or can assure the customers that their financial information is being handled securely, right? SOC 2, similar, but targets everybody else almost that provide information services. So if you are doing cloud services, now SOC 2 applies to, right? So you are cloud services is information services, right? So you are if you are a cloud service provider, you will go and get SOC 2 certification. So the SOC 2 applies to any organization that provide information services to others. Both SOC 1 and SOC 2 are details. They are written reports by the accountants, by this organization or its representative. And they are targeting also some technical people. So if let's go back to the example of the financial auditing, all right? So the financial auditors, they look at somebody's accounts, records, all of that, and they do auditing and they issue a report. The report probably not easy read by a regular person who doesn't understand accounting. So it has a lot of technical details. SOC 1 and SOC 2 is similar. They have a lot of technical details that maybe not the general public is aware of, right? SOC 3 is designed specifically for the general public. So SOC 3 is a report that is written in a language that the general public can understand. So what is the benefit of SOC 3? An organization wants to convince its shareholders or its customers that they are following good security practices, so they may ask for SOC 3 report. And the SOC 3 report will show the customers in a simple language that they are following good security practices. So let me read the last 2 points here. Both SOC 1 and SOC 2 are attestation reports, so reports that are written to say the auditors looked at all of these security controls and we affirm that they are in good standing in terms of these security measures, and they are the claims, they are we agree that they are doing this, right? The SOC 2 and SOC 3 reports are conducted according to SSAE 18 standards. I'm not going to go into these, but there are more specific standards that written or state how these reports are written and conducted came from the same organization here, right? So these are the SOC controls or the SOC reports. And then we have the third standards, PCI DSS, which is acronym for the Payment Card Industry Data Security Standard. This one is actually generated by the credit card industry, not just by one organization. The credit card industry includes all the organizations that issue credit cards. That includes American Express, MasterCard, Visa, all of this. And if you think about it, these are the brand names, but maybe you get a credit card from a bank rather than from Visa directly, right? So the credit card issuer is another organization that's part of it. So I think there's this list here of all organizations that involve in the credit card industry. So the merchants, the service providers, the acquirers, issuers, payment brands, customers, a long list. And it's out of the scope of this lecture to look into what each one of these means. We can recognize certain names, the customers, of course, the brands, the issuers. But that's not the goal of this lecture here. The point here is the industry that's involved in credit card. They recognize that the credit card information is the easiest thing the hackers can turn into money. All right? If somebody steals the number or recognizes the number of your credit card, they can go directly and buy stuff with it. Right? And hackers usually, one of the things that they want to steal from any organization is credit card information. They get the credit card information, they turn it into money as quickly as possible by just purchasing. And who is usually the one that pays the price is the credit card companies. If a credit card statement comes to you and recognize that, okay, there is $1,000 charge on my credit card and it's not me, you can complain to say, okay, you call 1-800 number and say, well, here I'm reporting unusual activity. There is a $1,000 purchase and I didn't do that. So the company will say, okay, great, we will not charge you $1,000. Who pays the price? The issuer. They eat the loss, so to speak, right? So because of that, they want to reduce the amount of fraud. They want to reduce the amount of money that they're losing. So they issued this standard, and the standard applies to one type of organization, right? Any organization that deals with credit card payments, it applies to them. So that includes if you go to a small merchant, a coffee shop, and you give them credit card to pay, that applies. The standard applies to them. If you go to the university and pay your tuition fees by credit card, that university or the standard applies to that university. So any organization that handles credit card information, the standards apply to them. Now, if you go deep into the standard itself, there are levels. So the small merchant will not be able to apply everything that the standard talks about. So there are levels of applications here, but I'm not going to talk about that for now. I'm just going to focus on certain aspect of the standard. So the standard So the standard scope is not the same for every organization, right? You can see here, depends on the size of the organization, they can have either their own self-assessment or use services of qualified security assessor to assess these transactions. Um, and also another thing interesting about the PCI DSS is that unlike the other organizations, the other certifications, it may apply only to one part of the organization. Okay, so what does that mean? Let's say back to the example of university. The university has a lot of information, right? Um, registration courses, patent, all of that, discoveries, everything, right? So but there is also one small part of this business, which is credit card information that being handled for tuition fees or for any type of payments. The university can just say, I am applying this PCI only to this part, only to the part that handles the credit card information. I'm not going to care about the rest of the systems that I have. So it could be also same thing for other organizations, that they can limit their focus and they say, we're going to apply the standard to only part of the information system that deals with handling credit card information, not everything in the organization. All right, so let's go on and see what other details. I chose this PCI DSS standards to get into more detail about the controls because it's interesting and it's actually widely popular among organizations here, and also because there are a lot of organizations that handles credit card information of different sizes, so it may be really useful for a lot of organizations. Okay, so the primary goal here is to protect everyone in the payment chain, all of these people or organizations here, by protecting or by preventing the loss of credit card information and reducing any vulnerability in the system that handle this information. The compliance process that's not different from the others, by the way. So the scope is determine which system components and networks are in scope of PCI DSS. You have big information system, a lot of things going on, but you may just focus on the part that deals with credit card information. Say, okay, here's the part that I want to protect. Other parts may fall under different standards or different regulations. I'm just going to focus on this small part. For example, you are a cloud service provider. Now, cloud service provider is a lot of big business with a lot of components. You may say, I'm going to apply the PCI DSS only on the part of the business that deals with handling credit card payments from the customer, right? While maybe the other parts will fall under SOC, for example, SOC 2. So determining the scope is important. The second step is assessment, which is examine the compliance of system components in scope following the testing procedure for each PCI DSS requirements. So now I'm going to look at what are the requirements of the PCI DSS, what is in place, and basically gap analysis, and what's the difference between what the compliance required and what I have in place. Reporting, you complete self-assessment that says, here's what I have, here's what I don't have. And then there is the attesting process, which is an auditor comes and look at what you wrote and say, well, yeah, we agree. You submit the reporting, and then if there are requirements, if there is a gap between what you have and what the compliance required, you can start going into a remediation, right? What do I need to do to fix the gaps? So this is the process. And as with any other certifications, this process goes in a loop, right? Goes in a, like, it's repeated, right? Every couple of years, every 6 months, whatever the process is, or whatever the requirements is, you repeat the process. PCI DSS requirements, now we have version 4 of it. Version 4, as well as previous versions, they have details. They have about the high level details are 6, and each one of them can be split into smaller steps. So in total, there are 12 requirements. So, for example, install and maintain network security controls, apply secure configuration to all system components, and so on and so forth. So, the reason of choosing this particular standard to focus on it, because some of these details, it's really related to what we studied in this course before, and we can look at them. So before I go into this slide, I'm going to show you some of the specific requirements. I'm going to show you requirements for PCI version 3 and version 4. So if you look, this is version 3 requirements, 3.2 to be exact, and you can see here, if I focus on some of these details, so let me see. Requirement number 1, install and maintain a firewall configuration to protect cardholder data. So this is requirement number 1, and you can look at the details here in the blue. These are the subheading: establish and implement firewall and router configuration standard that include the following. And then there are details: formal process for approving and testing all network connections, current network diagram that identify all the connections. So it tells you you have to have a network diagram that identify all the connections in the network, right? Current network diagram that identifies all connections between the cardholder data and environment and other networks. So if you are, just show me a diagram that shows where the cardholder information and how they are connected to the rest of the network, including any wireless network. So one of the requirements is give me a diagram, right? And it goes on and on. Build a firewall and router configuration that restrict connections between untrusted networks and any system components in the card holder data environment. You can go and see more detail. Prohibit direct public access between the internet and any system component. So this is a detailed, right? So don't allow any public access from the internet to the cardholder data environment. And you go on and on. So don't use vendor supplied defaults for system password. You can recognize that some of these things we talked about in other places in the course. So this standard provides very relevant information, right? And you go on. There are 12 of these points, each one of them split into more points. So in total, you may find about 300 or maybe less, a little bit less. So 276 lines here. So it's, let's say, 250 give and take requirements. Some of them are a lot of them related to networking, but some of them related to information security in general. So applications, servers. You can see here there is a mention of IDS, IPS. So all of these are very relevant to network security and information security in general. Version 3.2 of the standard has a lot of details. Version 4, which is the recent version, it actually more generic. I think they moved away from giving details, which is unfortunate, and they provided a little bit more generic information. So, for example, instead of specifically saying you have to implement a firewall, here they are saying install and maintain network security controls, and then they have more generic information. I think if you go into the details, you have to, it leads eventually to having a firewall, right? So you want processes and mechanism for installing and maintaining network security controls. So this is a more generic, but what is the control? So it's a firewall or other systems, IPS, IDS, for example. So they moved away from being specific, technical specific language to more generic, but you still see the the requirements here. So they're talking about multi-factor authentication here, audit logs, which we talked about in other places in the course, wireless access points. It's relevant also to our discussion. So you see a lot of information, whether it's in version 3 or version 4, a lot of relevant information to our discussion. So back to this picture here. So if you go to the requirements in version 3 in particular, so I didn't compare this to version 4 yet, but in version 3 you can see examples. I picked few things. For example, requirement 1.1.4, it says there is no public access from the internet to the cardholder information. Cardholder information environment means all the services, all the servers, services and databases, anything that has anything to do with credit card or cardholder information in particular. So cardholder are the people, right? So no access whatsoever from the internet to this. They also say in requirement 1.3.1 that the access from the internet to any public-facing servers like email or web, it has to be restricted. It has to go to DMZ. There's no access from a wireless network to the cardholder information. This is prohibited. So this is a requirement 1.2.3, I think. Also, any access from the internal network to this cardholder information environment has to be based on need basis. So not anybody who is inside the network can access this information. It has to be needed. So all of this, and the last one, 1.3.6, is the requirement for this system cardholder information to be isolated from everything else. Okay, so at the end you will see this compliance process, which applies to all standards that we talked about. So the idea is to understand what the requirements are for compliance, and then build whatever is needed to meet that requirement. Fix any gaps. So there is always a difference, right, between what the requirements needed and what you are doing. So you fix any gaps in the process and you repeat in a continuous cycle. The idea behind it is that nothing is static, nothing is fixed. So whatever you do today, any change in the business, that means that you have to go and revisit your security controls again, right? You start a new service that you haven't had before. So now with the new service, there are risks involved. So you need to go and update your security controls. You add new branch to your organization or new site, new building. So this means that there is the infrastructure changes, service IT infrastructure changes. So you need to update your security. So all of this, because there are always changes in the environment, the organization environment. So this process is always repeated, and that's why the certification given to organizations never fixed, is never one time. It has to expire sometimes in 1 year, sometimes in two, sometimes in more. It depends on what what the standard is, but you have to follow this process all the time, doing auditing, fixing any gaps. Sometimes the auditor comes and say, okay, here is gap you have there, this is what the standard says, but you are not doing this, so you have 3 months or 6 months to fix, otherwise you will lose your certification. So the organization will go and fix that and then come back and say, okay, now take a look again, see if we're doing well, and then the certification is issued to them, right? So this is the audit process, and it goes continuously. Okay, so we covered all the standards, or three of the standards, or three groups of standards. Now we're talking about regulations. Regulations are mandatory, so you cannot escape them. Right? So they are issued by governments, and you have to follow them. Same with the standards. Not all regulations apply to everybody. And of course, the regulation apply not just to certain types of organizations, but also to certain jurisdictions. So the Canadian regulations don't apply to Americans, American regulations don't apply to Canadian. And I focus here on the regulations, the Canadian regulations. There are a lot of books and certifications that when you read them, they are basically talking about American regulations, which don't apply to us in Canada, right? So the focus here on the security regulations, Canadian security regulations. Although sometimes in Canada they follow certain regulations issued by the Americans. Now they are not mandatory, but they follow them for the sake of, trying to follow best practices here. Okay. So before I start, I need to talk a little bit about the jurisdictions of Canada. So Canada is follows a federal system where there are provinces and there are the federal government. The provinces have their own jurisdictions, so every province has a government. The provincial government has certain scope, certain jurisdiction, and then the federal government has other jurisdictions, so there are different roles for each. And because of this, laws that apply to one province don't necessarily apply to other provinces. The federal laws apply to everybody, but the provincial laws apply to only the province that they belong to. Okay, because of that, we're going to talk about two levels of regulations: the federal regulations and provincial regulations. Okay, so we'll talk first about the federal regulations. So there are several regulations that apply at the federal level. So here, as the slide says, there are several laws in Canada that relate to privacy rights. So we're going to talk about privacy first. Enforcement of these laws is handled by the various government organizations and agencies, and there are several factors determine which laws apply and who oversees their enforcement. So the first type of organization that handles the personal information, either government or private business, location of the organization, the type of information, and whether the information crosses provincial and national borders, right? So these, you have to focus on these four aspects when we talk about the laws here. Okay, so we'll talk about privacy first. So we have different laws that protect privacy. The first one is called the Privacy Act, which is a federal legislation. And we have something called the Personal Information Protection and Electronic Documentation Act, or Documents Act, which is PIPEDA for short. Then there is provincial privacy laws. There are the Criminal Code. There's the Health Information Acts, and there's Bill C-26, which aims to enhance cybersecurity in Canada. So all of these are federal and provincial regulations that are applicable to Canada. Okay, there is a lot of things about privacy in Canada. So there are a lot of laws that deal with privacy. So what does privacy mean? So let's talk about what it means to have what personal information means, right? So before we talk about privacy. So what considered personal information in Canada include race, national, or ethnic origin. All of these are personal information. Religion is personal information. Age, marital status, medical, educational, or employment history, financial information, DNA, any identifying number such as your social security number or social insurance number or driver's license, any personal opinions or views except if they are about other individuals. So if you want to talk about if your personal opinion about anything is considered personal information. So when we talk about privacy, we're talking about protecting all of these, right? So when we say privacy laws, we mean protecting all of these 8 different pieces of information. So in general, any of these are protected unless there are some exceptions. One of them is written here is if you are saying if you are writing an opinion about somebody else, right, and a personal opinion about somebody else, then this probably is an exception. Now that you are talking about somebody else, this is not private information to you, so it's not protected. All right, so let's take a look at the regulations that protect personal information. So if we go back one slide here, so when we talk about the right to privacy, in Canada, there is a fundamental right for Canadians, which is the right to privacy, and it is enforced by different laws, such as the Charter of Rights and Freedoms, the Privacy Act, and PIPEDA. Right? And when we talk about protecting privacy, we mean that the personal information should be collected directly from the person who is about, and the individual should be informed about the purpose of the collection. So you cannot just go to the university, for example, and collect information about students without them knowing, right? So the government cannot go to the university and say, hey, here, we need a list of all of your students, their numbers and their grades and all of this, and we just want to collect this information. That doesn't happen, right? So even if they wanna collect it for legitimate reason, they have to get the individuals have to be informed, right? And that applies to different organizations as well. So you go to a bank and give them information, right? So I'm gonna talk general here, but I'll give you more details later. So you go to the bank, and the bank you give them some information. Or you go to the taxes, or let's make it all about government. So you go to Revenue Canada and give them information. Now, the um, let's say Foreign Affairs cannot just go to the Revenue Canada and say, "Give me information." No, it doesn't work this way. Okay, so it has to be collected directly from the individual, and the information, if they want to uh, if they and the individual have to be informed about the purpose of the collection. And when it's collected, the information collected, it has to make sure that it's accurate and also up to date. And this information has to be used only for the purpose that it's collected for. So you cannot collect information about a user, about a person, for a specific person for a specific reason, and then you go and use it for something else. So all of this is general rules that um, implemented by different laws. Okay, so I talked about personal information. What is not personal? Anything that's information about organization is not personal. Information that changed to be anonymous is not personal. So a list of students with their grades, that's personal because we have the names of students and their grade. But if I remove the students' names, right, and replace them with ABC or any code that doesn't indicate the person, that's okay. Now it's not personal anymore, right? Public users, public employees, the people who are considered public employees in Canada, their positions, names and positions and titles is not personal. Their address, home address, of course, it's personal, but their name, position, and title is not personal. Business contact information, my business contact, my number in the university, my phone number, my room number is not personal information, right? Any government, or a lot of government information is not considered personal. Okay, so the first law that handles privacy information is called the Privacy Act, and the Privacy Act applies to federal government only, right? So it doesn't apply to private business. Applies only to government, and it controls or handles or specifies how the government handles personal information, and how it collects it, and how it discloses it if necessary. So the Privacy Acts relates to personal right to access and correct personal information that the government of Canada holds about them for purpose of providing services. And some of the information includes, for example, the old age security pensions, employment insurance, border security, federal policing and public safety, tax collections. So all of this are services provided by government, and it requires collecting information from people. So the Privacy Act itself, when we talk about the provisions, means we're talking about the details of the law itself. So it specifies the personal information, what personal information means. So it defines it, and it defines a requirement for handling personal information. So the government institution may only collect personal information that's directly related to one of their ongoing programs or activities. If the information is used to make a decision that would directly affect a person, it should be accurate and collected directly from that person. Another provision is the use and disclosure. So the government institution may use or disclose your personal information with your consent. So if they want to give the information to somebody else or disclose it for public use for any reason, they have to get your consent. For example, I'll give you an example. For every 5 years, the government of Canada has statistics, goes and do a survey, and the survey will ask households, how many people in the household, what are their genders, are they employed or not. So a lot of information, and these statistics is used to make decisions about development, about taxes, about sometimes elections, all of this. And one of the things that you have to you have to answer is that, well, in 90 years from now, are you okay if we disclose your name, right? And you can say yes or no. You can say, well, for history, like 90 years from now or 100 years from now, right? So I may be long dead, right? So I don't mind releasing my actual name with my personal information by that time. Or you may say no, right? So even in this case, they have to get your consent. Access and correction. So the act also gives people the right to access their personal information held by the federal government. So if you are suspecting that some of the information is probably wrong, and you want to make sure that the information is correct, you can go to the organization, the agency, the department that collected information from you and say, can I see what you have about me? So they have to show you the information that they collected from you, and if you want to make corrections, you can do that. So all of this is protected. There are exceptions, and you have to be aware of the exceptions. So the exceptions: personal information may be disclosed without an individual consent, one, for the purpose of complying with warrants and court orders. So if there is a court order that says we need this information, now the department, the government has to provide this information, right? So sometimes the disclosure is authorized in federal legislation. If the parliament comes up with a law that says this information has to be disclosed, then it has to be disclosed. All right, so a law that says you have to do this. Sometimes the disclosure would clearly benefit the individual. So releasing the information is actually beneficial to the person. Okay, so we are looking for an individual, missing individual, for example. Here is his name. Here, and he has been missing since 3 days ago. So that's actually benefiting the individual, because now people will go and try to find him. And finally, if the public interest in disclosure outweighs the invasion of privacy. Right? So sometimes you have a criminal with a serious crime released from prison, finished their sentence, and they are living in a certain area. Sometimes the government wants to say, well, this offender finished his sentence, he's free, but we want you to know that he is living in your neighborhood. Right? So these are some exceptions. So who it applies to? Notice that we're talking about the provisions, we're talking about the law in general, we talked about the provisions, and who it applies to. It applies to federal government institution, as I said before. It doesn't apply to private business, only to the federal government departments, and also something called crown corporations. So uh, some businesses, they are owned by the government. We call them crown corporations in Canada. So they are, for example, the Canada Post. Canada Post is business run as a business, but it's owned by the government. So there are many crown corporations like that, and those corporations, they should follow the Privacy Act as well. So the Privacy Act applies to them, right? So you can see here examples. Some departments like Agriculture and Agri-Food Canada, that's a department. Via Rail is another example of Crown Corporation. Canada Post is another example. Bank of Canada is another example. These are all examples. The three bottom ones are Crown Corporations, while the Agriculture Canada is a department, right? A ministry, in other words. Okay, so there are exclusions as well. The Act does not apply to political parties, does not apply to political representatives. So these are actually they don't have the same rights to privacy as the rest, because they they are public figures. Courts, anything that goes through the court is public record, right? So any lawsuit, any judgment from the court is a public record. So the Privacy Act does not apply. Private sector organizations also, they don't have to follow this, right? They have another law that applies to them, which we'll talk about. This is the one that applies to businesses, called the Personal Information Protection and Electronic Document Act. So PIPEDA sets the rules for how private sector organizations collect, use, and disclose personal information while conducting commercial activities across Canada. It applies also to some businesses that are federally regulated, not necessarily crown or corporations. So they're not owned by the government, but they are regulated by the government. So banks, except with Bank of Canada, but banks in general, they are private businesses, but they are regulated by the government. Airlines, also another example of private business, but they are heavily regulated by the government. Telecommunication companies also are regulated by the government. So all of these, they have to follow PIPEDA. So either totally private business or private business that federally regulated. The provisions, so what does PIPEDA says? PIPEDA says that organizations covered by PIPEDA must generally obtain individual consent when they collect, use, or disclose that individual's personal information. So before they collect any information from you, they have to get your consent. They have to make sure that the information is accurate, and the people have the right to go and look at the information collected about them and correct them if necessary, right? So you can go to a bank and say, what kind of information you have about me? And then you can say, I want to change this information. This information is not accurate, right? And that applies to something maybe trivial like your phone number or your email, right? Or it could be something more significant than that. Limitations: the personal information can only be used for the purpose for which it was collected. So the bank collects information from you, and they cannot use it for other purposes. They cannot sell it, for example. Right? This is one aspect. Some organizations will collect information and sell it to advertisement agency, right? Or that's not allowed. If an organization is going to use it for other purpose, they must obtain consent again. Someday the bank wants to use this information for even for statistics, right? They may need to ask your permission, unless you told them you can use this information for research, for example, right? Personal information must be protected by appropriate safeguards. This is where PIPEDA may overlap with some of the standards that we talked about before. So the PIPEDA says the personal information that you collected, you have to protect it. You cannot just do the top three and leave the database vulnerable, right? You can still get your consent. They can still make sure that the information is accurate. They can still use it for only the purpose that they want, but they don't put it in a secure database so somebody can hack it. Well, then they are in violation of PIPEDA. PIPEDA doesn't follow the following: personal information handled by the federal government, so that's under different law, of course, Privacy Act. The provincial and territorial governments, PIPEDA doesn't cover them. So I mentioned here that the Privacy Act applied to the federal government, does not apply to these people here, the political parties and courts and all of that. And PIPEDA, the Privacy Act also does not apply to provincial and territorial government, neither PIPEDA. So these guys, the provincial and territorial governments, they have to have their own privacy, which probably because the Privacy Act is federal, so they probably follow it anyways. But PIPEDA does not cover the provincial and territorial government. Business contact information such as employee name, title, business address, and phone numbers does not apply or is not covered by PIPEDA. It's not covered by the Privacy Act either. So your business information is always public. Individuals' collections, use, and or disclosure of personal information strictly for personal purposes, example, personal greeting card list, also does not apply or is not covered by PIPEDA. Anything that you need or it's used for journalistic, artistic, or literary purposes also is not considered part of PIPEDA. So there are some areas where they can use some information for journalistic purposes. So, for example, there's an article and it mentions a name, right? So that's probably because of journalistic reasons. You cannot just go and say, well, you published my name, right? That's breach of PIPEDA. No, that doesn't apply. Although probably they have to use your consent anyway that's a different story. Reporters they cannot publish your name without your consent anyways. PIPEDA applies to organizations that conduct commercial activities. The law defines a commercial activity as any particular transaction, act, or conduct, or any regular course of conduct that is of a commercial character, right? So this means that if organizations do anything for commercial purposes, then PIPEDA apply to them. So if a business, not a business, but if a university, for example, notice that we didn't mention it in any place here. It is not part of the Privacy Act, it's not a commercial business. But if the if the business, if the university does business of any sort, PIBIDA applies to that business. Okay? All businesses that operate in Canada and handle personal information that crosses provincial and national borders for commercial purposes are subject to PIBIDA. So a business that carries traffic between two provinces, information traffic between two provinces, automatically falls under PIBIDA. Now, this is important to remember because we will see how important when we look at the exceptions later. But if a business in province A does business in province B and there is personal information is carried between these two provinces, then that information is under PIBIDA, right? Federally regulated organizations that conduct business in Canada are always subject to PIBIDA. The Act also applies to their employees' personal information. So federally regulated organizations, we talked about them, also like banks and airlines, they fall under PIBIDA as well. All right, so I said that twice. Exclusions. So what does PIBIDA, what doesn't fall under PIBIDA? PIBIDA does not apply to organizations that do not engage in commercial for-profit activities, such as charity groups. They're not doing business, so PIBIDA doesn't apply to them. Political parties and associations, also they're not doing commercial business, so PIBIDA doesn't apply to them, right? You can see political parties are exceptions here from many things, maybe because they are the ones who set these rules, so they make themselves exceptions in all of them. Maybe I'm just being cynical here, but they are excluded from all of these rules. PIBIDA generally does not apply to municipalities, universities, schools, and hospitals. Again, municipalities are the third level of government. So the first level of government is federal, then the provincial, and then municipal. So PIBIDA does not apply to municipal governments nor to provincial governments here. Universities also are not part of, or that they don't have to follow PIBIDA. Hospitals don't need to follow PIBIDA, but that doesn't mean they don't follow privacy, right? Because there are other laws that apply to them. We'll see them later. Except if they are engaged in commercial activity. So if the hospital does sell merchandise, does sell souvenirs, right? Now they are doing commercial, right? Hospitals in Canada, they are not commercial entities. They are and they are not for profit, so PIBIDA doesn't apply to them. But if their part of the business is commercial, then it will apply to them, to that particular business. PIBIDA does not apply to organizations that operate entirely within Alberta, British Columbia, and Quebec. So these are 3 provinces out of 10 provinces and 3 territories that do not have to follow PIBIDA if the business entirely follow under or contained within these 3 provinces. Why? Because they have their own privacy laws. So there is an exception. And as I said before here, if one of these businesses, let's say Quebec, if a company in Quebec is doing business also in Nova Scotia, then PIBIDA apply to them. If there's any cross or inter-provincial business, then it applies to them. But if the business is doing only business in Quebec, then PIBIDA does not apply to them. Instead, they follow the law related law for Quebec. Okay, so that's PIBIDA. Now we'll talk about another legislation that follows, that's federal. We're still talking about federal legislations here. So there is the anti-spam legislation, Canada anti-spam legislation, or CASL, probably, if I pronounce it correctly. That law was created specifically to protect against spam or any similar. So emails that are considered spam, they are prohibited under this law, under the penalty, of course. There are all penalties, right? The law requires, well, first of all, applies to all organizations that do business. And just to make sure that these businesses do not engage in spam, they have to follow this law, and especially when they communicate with any electronic messaging, right? So for example, if you receive a message from any business, it has to have identification of the organization. It has to say specifically, we are Bank of Nova Scotia, for example, right? It has to include the mailing address, phone number, email address, or a web address for the organization. So it cannot just send you an email without identifying themselves or giving you their contact information. It has to include unsubscribe mechanism. So any email that comes from a business must have way to unsubscribe, and it has to be truthful in the advertisement. And I forgot to mention something really important, that the business cannot connect you at all, whether they follow this or not. They cannot contact you at all unless they have your consent, right? Generally speaking, if you have a business with, let's say, one of the banks, Bank of Nova Scotia, again, Scotiabank, right? Well, then they can contact you. They don't have to have consent. They can contact you to tell you about, maybe they advertise a new credit card for you, for example. So they can tell you that. They can say, okay, as a customer, we are offering you this new service, etc., etc., right? And they have to include all of the information, identify themselves, include contact information, include unsubscribe mechanism, and be truthful about the advertisement. But let's say another bank, the Royal Bank, they cannot contact you because you are not their customer. They cannot contact you by any means, right? So that's really important to know, right? And when this act was introduced, a lot of organizations, that even the ones that you have business with, they started sending emails, getting consent. They said, can you give us your consent for, to contact you in the future and give you advertisement about our new services. So you reply, say, okay, yes, or maybe no. So that's because of this law. Another aspect of this law, another provision, is the law requires that a business cannot install a program on your computer or mobile device before getting the owner's consent. Also, some organizations, maybe they found a loophole at some point. They sent let's say you are getting a free, a good example is a free antivirus, right? So you download a free antivirus, and because you now you are a customer of that organization that gives you a free antivirus. But then they start sending you, while downloading the antivirus, they download a web browser, so a secure browser, and all of a sudden you'll find that once you want to go to a website, their browser comes up instead of your default browser. So now that's a problem, right? Problem because you didn't give your consent, and problem also because, well, this is another way of probably passing a malware. So now the anti-spam says, no, you cannot just download anything without the consent. Usually the consent comes as a checkbox in the email. So by downloading this piece of software, you also agree to download this piece. So you can uncheck so that you don't download the other piece, right? So these are the parts of the anti-spam legislation. The anti-spam legislation is enforced by three agencies. The Office of Privacy Commission of Canada, which, by the way, enforces the other legislations as well. So the OPC. So if you receive a spam from somebody who's not a previous business provider to you, you don't have any relationship with them, or somebody who sent you information with any of these missing, then you can complain about them. And I remember the penalty of this is really severe. It's like I think it's $100,000 per email. So it was really severe, and some people called it draconian when it came out. Because a lot of businesses were afraid that they may be targeted maliciously by people, right, just by sending advertisement. Another agency that can enforce this is the Canadian Radio, Television and Telecommunication Commission, or the CRTC, and the Federal Competition Bureau. Either one of these, you can contact them and complain about an organization that you think is not following this law. The Privacy Commission of Canada is it was created as a result of the Privacy Act. So the Privacy Act created the Office of Privacy Commission, or OPC. It's an independent agent of Parliament that oversees compliance with the Privacy Act, PIPEDA and CASL. So all the acts that we talked about, the federal acts, are under this commissioner. So if you want to complain about any organization that is not following the Privacy Act, which is a government, or PIPEDA, which is a commercial, and CASL is also commercial commercial business. So you want to complain, you go to this place. So the Privacy Commissioner has powers to receive and investigate complaints, and the OPC also provides guidance and resources for businesses on how to comply with PIPEDA and CASL. So if you are a business and you want to make sure that you are complying with all the regulations, so you may contact these and they will give you guidance on how to apply them. So these are the equivalent of the government's equivalent of those organizations, the standard organization that issues the standards. They give you how to comply with the standard. This Privacy Commissioner, they will give you guidance on how to implement these regulations, right, or how to comply with these regulations. Okay, so now we are moving from the government, federal privacy-related regulations, and we move to provincial. So every province has its own regulations that apply only to the organizations within that province. So I picked one because we didn't talk about health. Um so health information is really important. Your health record is important as part of the personal information that it doesn't want you don't want to disclose. So each, or at least Nova Scotia, has a Personal Health Information Act that governs this, and it talks about how to collect, use, and disclose, and retain, and eventually dispose and destruct of personal information. So the life cycle of the information starts by collecting, using, disclosing, retention, which is keeping, and finally disposing and destruction of the person. So it governs all of this, every aspect of the life cycle of the information. The Act recognizes both the right of individual to protect their personal health information and the need for custodians to collect, use, and disclose personal information. So, what does that mean? Okay, I have the right to protect my information, health record, whatever treatment I have, whatever health conditions I have. But also, um, if I go to a doctor and the doctor will let's say uh, prescribe, well, um, I need an X-ray. So the X-ray is not performed by the doctor; it's performed by another uh, person. So there is need to share some information about you, right? So you cannot just say this information cannot be shared. So you have to have a shared. You have to have a limit on, or you have to have some exceptions that allows healthcare providers to handle this information. So it has to balance between protecting the privacy of the individual and also giving them the proper information. But something also important here is that this information, the private information, does not need to be shared with people unless they need to. Right? So, a relevant example, let's say you go to a doctor, you are sick, and the doctor will say, uh, take this medication, stay home for 2 days. And they will give you a note to skip classes. The note that's it shouldn't, it must not include what kind of illness you have. It just says that this individual um, needs to stay home for 2 days, and nobody can ask you why. This is private information to you, and you can the only thing that you need to share is that the doctor says you can stay home, right? So you don't have to share any um, information about your medical status. And finally, so all these regulations will come with a penalty, right? So if you don't follow a standard, what happens? You lose the certifications, all right? But if you don't follow the regulation, there is a penalty. The penalty can be a fine, can be even prison. It depends on the law. So a person can be fined if found guilty of collecting, using, or disclosing, or attempting to gain access to health information in violation of the act. So a nurse cannot go and look at information of a patient that without authorization, for example, right? Um, the last thing that I want to talk about, it's still federal law, right? But it's not really related to security in specifically, but it's relevant to security, right? So the criminal code The criminal code actually has some provisions that are really important in terms of security. Uh, it says that it's an offense to fraudulently obtain, use, control, access, or intercept computer systems or functions under the criminal law. So now if you're not covered by the previous laws, there's still you may be the hacker may be under the penalty of the criminal code. So if you look at the first line here, this means that if somebody hacks into a system, even if they don't steal anything, right? Well, they are committing criminal acts. Denial of service attack is part of this as well. So because they are intercepting traffic here. The relevant provisions of the criminal code that prohibit hacking, i.e., unauthorized access, are as follows. Section 184, any person who knowingly intercepts a private communication is guilty of an indictable offense carrying a maximum penalty of 5 years imprisonment. So Canada here says that just intercepting, eavesdropping, it can carry a penalty of up to 5 years in prison. Another section 342.1, any person who fraudulently obtain any computer services or intercepts any function of a computer system is guilty of indictable offense carrying a maximum penalty of 10 years. Again, this is obtain any computer service illegally. It carries 10-year prison. Any person, the next section, section 380, any person who defrauds another person of any property, money, valuable security, so steal, or any service is guilty of an indictable offense carrying a maximum penalty of 15 years imprisonment where the value of the subject matter of the offense exceeds 5,000. So if a hacker manages to steal something by hacking into a system that has a value of 5,000 or more, then they may be subject to a penalty of 14 years. Notice that the penalties are increasing continuously, right? So from 5 to 10 to 14, it depends on the offense. Section 430, any person who commits mischief to destroy or alter computer data, render computer data meaningless, useless, or ineffective, obstruct, interrupt, or interfere with the lawful use of computer data, or obstruct, interrupt, or interfere with a person's lawful use of computer data who is entitled to access it is guilty of an indictable offense punishable by imprisonment for life if the mischief causes actual danger to life. You see how serious. So a hacker tries to, let's say, create a denial of service attack to a hospital, right? And the result is a patient in the intensive care unit loses life support and dies. Well, now the hacker goes to prison for life. So, and of course, there's anything in between, right? So it could be maybe not as severe as this, but still they may fall under this law. So hacking carries a lot of penalties under the criminal code. And now, if you look at just a review of what we talked about, all of these regulations, they are privacy regulations, right? If you go from the beginning here, the regulations talk about protecting the privacy. We talked about protecting the privacy under federal laws. There are the Privacy Act which defines what the personal information is, or actually the personal information is defined, generally speaking, um, in these terms here. And then we have the Privacy Act, or the right to privacy. The right to privacy actually is almost part of the Constitution, right? So that's part of the Constitution. Constitution in Canada is actually multiple documents, not just one. And the Chart of Rights and Freedoms is one of them. And also, we have this right to privacy as part of it. So the Privacy Act is the law that applies to federal organizations, government organizations at the federal level. PIPEDA applies to commercial organizations. And then we have the anti-spam legislation, not necessarily protecting the privacy, but protecting people from spam. So slightly different goal here. Then we have the health information, which is an example, or Nova Scotia health information, which is an example of protecting a specific type of information, which is the health information. And then we'll talk about the criminal code, which prohibits hacking in general, right? So regardless of whether the goal is stealing information, personal information, modifying it, or whatever, or just preventing people from using the information system. Right? So all of these are relevant regulations in Canada, and this concludes this topic, and I hope you gained useful information from it, and we'll see you in the next one.